So you didn't have an inkling that you would get questioned and questioned pretty vigorously about a decision with egregious consequences that was unanimously reversed by the Court of Appeals?
Did I have an inkling that I would be questioned about the Spanier case? Yes, Senator, I did.
Let me ask you this. Did then Pennsylvania Attorney General and now Democrat Governor Josh Shapiro praise the Third Circuit's reversal of your opinion?
What you just watched is not political theater. It's accountability in real time. This exchange is one of the clearest examples of why confirmation hearings actually matter. Senator Ted Cruz didn't come in swinging for headlines. He came in armed with facts, appellate rulings, and moral clarity. And instead of getting straight answers, what we saw was evasion, lack of preparation, and an alarming detachment from the gravity of the case. We're talking about a decision connected to the Jerry Sandusky child abuse scandal, one of the most disturbing criminal cover-ups in modern American history. And yet, the nominee at the center of this hearing couldn't even recall the most basic precedents that got her ruling unanimously overturned. That should concern every American, regardless of party. I'm Audrey, this is Congress Lens, and if you believe judicial nominees should be held to the highest possible standard, especially when children are the victims, then like this video, subscribe to the channel, and let's get into it.
Thank you, Mr. Chairman. Welcome to each of the nominees. Judge Mihalchik, I want to talk to you about a case you've already discussed considerably, which is the Spanier versus Libby case. That's a case involving Graham Spanier, the former president of Pennsylvania State University, who was investigated, terminated, subsequently criminally charged for his role in covering up the child sex abuse crimes committed by Jerry Sandusky. The sentencing memo written by the prosecutors in that case, state case, noted that Spanier had, quote, shown a stunning lack of remorse of his victims. It further called for him to be punished for, quote, choosing to protect his personal reputation and that of the university instead of the welfare of children. It further highlighted that Spanier, quote, was the ultimate decision maker when it came to reporting Sandusky. Your decision in that case was reversed unanimously by the Third Circuit. Is that correct?
A three-judge panel of the circuit reversed my decision, yes.
Unanimously.
Yes.
The Third Circuit concluded that, quote, under clearly established federal law, state courts have considerable latitude to rule on the meaning of statutes. Yet you construed the rule more narrowly than the state courts to Spanier's benefit. Jerry Sandusky was an evil man. And Spanier, the ultimate decision maker, protected his own reputation at the expense of the children. Why did you deviate in your decision from clearly established federal law, particularly when it had the effect of protecting such a man?
Senator, the crimes of Jerry Sandusky are beyond horrible. They are unspeakable, and as a member of the community and as a mother of two children, they are the worst nightmare for most parents. That was not absent from my mind when I was looking at the case before me. The issue before me was whether the petitioner, who I looked at and treated as I would every habeas petitioner that comes in front of me, received due process in state court. I determined that there had been a violation of his due process rights in the use of the jury instruction that the state court had, and the Third Circuit disagreed with me.
The Third Circuit did more than that. Did the Third Circuit criticize your opinion for not only admitting relevant precedents, but also for not closely analyzing the case law that you did cite?
I can't recall verbatim what the Third Circuit opinion said. As I recall, there were three cases involved in that case in terms of precedent, and I relied more heavily on one of them than the other two.
Do you recall the names of those three cases?
I know one was the Bowie case. I can't recall the names of the other two.
Well, here's what the Third Circuit said, quote, the district court cited Bowie and Rogers but did not examine them closely, nor did it mention Metrish. Now, I do find it a little bit amazing. You knew in this confirmation hearing you'd get asked about this case.
Yes, Senator.
I find it actually quite remarkable that for this hearing, you still don't even know the three cases the Third Circuit said were critical to resolving the issue of law.
Senator, I reviewed 10 years of work in preparing for this hearing. I don't recall those three cases specifically.
So you didn't have an inkling that you would get questioned and questioned pretty vigorously about a decision with egregious consequences that was unanimously reversed by the Court of Appeals?
Did I have an inkling that I would be questioned about the Spanier case? Yes, Senator, I did.
Let me ask you this. Did then Pennsylvania Attorney General and now Democrat Governor Josh Shapiro praise the Third Circuit's reversal of your opinion?
I don't know what his comments were following the issuance of the opinion.
Well, I will point out that he released a press release, statement by the Attorney General Josh Shapiro on the U.S. Third Court of Appeals ruling reinstating the conviction of Graham Spanier, and you can read that, and he was effusive in his praise. There's a long and unfortunate pattern in this administration of Joe Biden nominating individuals to serve on the bench who have a repeated pattern of showing excessive leniency to criminals, of releasing violent criminals from jail, of releasing murderers from jail, of releasing rapists from jail, of releasing those who committed child sexual assault from jail. I don't believe doing so is in the interest of the American people. I think it is contrary to the views of the constituents of just about every one of ours. But nonetheless, that pattern continues, and the consequences are deeply harmful.
Record 2 letters in support of Judge.
After watching this entire exchange, one thing is crystal clear. Senator Ted Cruz was absolutely right to press this issue, and to press it hard. This wasn't about relitigating Jerry Sandusky's crimes. Everyone agrees those crimes were monstrous. What Senator Ted Cruz focused on, correctly, was who enabled that abuse and how the justice system treats those enablers. Graham Spanier wasn't some low-level bureaucrat. Graham Spanier was the president of Penn State University. Prosecutors made it clear he was the ultimate decision-maker and that he chose institutional reputation over the safety of children. That matters. Now here's the key issue. Judge M. Casey Rogers issued a decision that benefited Graham Spanier, and that decision was unanimously reversed by the Third Circuit Court of Appeals. Not split. Not controversial. Unanimous. And the appellate court didn't just disagree. It criticized the reasoning, pointing out that Judge Rogers failed to closely analyze controlling precedent and ignored key case law altogether. That's not a minor mistake. That's a foundational failure. So when Senator Ted Cruz asked a very basic question, can you name the 3 cases the Third Circuit said were critical? And the answer was essentially no. That was a flashing red warning sign. This nominee knew this case would come up. She knew it was controversial. She knew it was reversed unanimously. And yet, she walked into a Senate confirmation hearing without mastering the most important legal criticism of her own ruling. That's not about memory. That's about judgment and seriousness. Senator Ted Cruz was also right to highlight the broader pattern here. This administration has repeatedly nominated judges who show extraordinary leniency toward violent offenders, including those connected to sexual abuse cases. When that leniency benefits powerful people who helped cover up crimes against children, the public has every right to be outraged. And let's not gloss over this point. Josh Shapiro, then Attorney General of Pennsylvania and now Governor, publicly praised the reversal of this decision. That alone tells you how far outside the mainstream this ruling was. What Senator Ted Cruz did in this hearing was simple but necessary. He drew a line and said, "Judicial philosophy has consequences. Due process matters, but so does accountability. And protecting children is not optional." This wasn't cruelty. This wasn't grandstanding. This was a senator doing exactly what the Constitution requires him to do: advise, consent, and scrutinize. If this hearing made you uncomfortable, good. It should, because lifetime judicial appointments demand more than credentials. They demand judgment, preparation, and moral clarity. And on that standard, Senator Ted Cruz didn't just ask the right questions, he exposed the right concerns. Let me know your thoughts in the comments. This is Congress Lens, where accountability stays in focus.